welcome all of you who are joining us on television right across Guyana. Welcome to another program of Issues in the News. And to the thousands of you who are joining us on Facebook Live across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, and further afield. Welcome to another program of Issues in the News. I met a group from region number 7 from the Upper Mazaruni Cayuni area, and they said to me that they look at this program very religiously every Tuesday, and they asked me to give them a shout out. So all of you in the Upper Mazaruni Cayuni area, greetings from Issues in the News. Press the share button. Press the share button on your phone. Press the share button on your computer. Share this program on your iPad, on your tablet, or whatever instrument you're using to look at the program. Share it wide and far so that all your friends and all your family, all your followers can become part of our audience. I see Shamo Gear, let me see, Jack Jagdeo Kumar Singh, Malaram Nath, Churanlal Silo Chan, Surendranath Prasad, Neetu Nurse, and so many of you. Share the program, share the live so that all your friends and followers can join us in tonight's discussion. Use the comment section of the program, use the comment section to register your views, ask questions, raise issues for discussion, and make any type of inquiry that you may wish for me to address. So please share the program. Effect claims during the claims and objections period granted by GCOM to get your name on the voters list. A process began Monday and it will conclude Wednesday, tomorrow. And that 3-day window would have given every one of you who are qualified to have your names registered to do so at any registration office. GCOM's registration office, and there are GCOM's registration offices across the country. Tomorrow is the last day for you to make a claim to be registered. From Thursday to Friday, they will be dealing with objections. That is to say, you will be able to go and object to any person whom you think should not be on the list and whose name is on the list, or any other matter on the list that you find objectionable. You have from Thursday to Friday to get those transactions done. But tomorrow would be the last day, once you are qualified, to get your name on the list. So PPP and supporters in particular, I am appealing to you. Tomorrow is the last day for you to get your names on that list. Remember, elections are won by voting. And to vote, you have to get your name on that list. And tomorrow is the last day for you to do so if you wish to vote at the September 1st general and regional elections. I hope that my advice would not fall on deaf ears. So please ensure that you attend the nearest registration office close to you and you have your name placed on that list. Have you yourself registered so that your name can be placed on that list once you are qualified to register. about this character by the name of Baby Skello. And a lot of public exchanges are taking place. I will not be dragged into the exchanges. What has caught my attention and which I believe is worthy of comment is the contention, I think, by the PNC, APNU, that the government is responsible for the institution of criminal charges or a criminal charge against this person, and the government is responsible for the decision of a magistrate that remanded this individual. As trite and as settled as the position is, it is worth reiteration that governments in a democracy governed by a constitution that embraces the doctrine of separation of powers are not responsible for or charged with the responsibility of instituting criminal charges against any person. Our government is in that position because we are governed by a constitution that embraces the doctrine of separation of powers. In Guyana, investigations are carried out by a police force that is not under the command, direction, or authority of our government, but under the direction and command of a commissioner of police. The Minister of Home Affairs, who holds responsibility for the Guyana Police Force, is by law only permitted to give policy directions of a general and specific nature, and that is set out in the Police Act very explicitly and very clearly. So there is no government or government minister that can instruct the police, and our government doesn't do that. Other governments may have done that. And in terms of what charges are to be instituted, the police has their own internal agencies and procedures through which they get legal advice for the purpose of the institution of criminal charges. There is a police legal advisor, and then the police would normally seek the legal advice of the Office of the Director of Public Prosecutions, an independent constitutional office, and an office that is insulated under the Constitution from any type of direction and influence of a political type. These, as I said, are trite and settled matters, and one would think that people would know this by now. But the PNC, having regard to its history and having regard to the way it conducted itself while it was in government from 2015 to 2020, and from 1964 to 1992, they believe that every other government behaves like them. Because it is no secret that when they were in government, from 1964 to 1992, they controlled the judiciary. They had the flag of the PNC flown atop the Guyana Court of Appeal. They controlled the police force, and there is an abundance of evidence to that effect. And when they were in government again between 2015 to 2020, They instructed the police who to charge and who not to charge. I am a victim of that. Basil Williams, the Attorney General, instructed Soku Head to charge me, and many others, including the President, now the President, or the now President. Politically directed charges. That is not the position here. So those who are putting these decisions at the foot of our government is wrong. We don't instruct, we don't mandate, and we are not responsible, certainly not responsible for decisions that the courts make. Many times on this program, I've expressed my own views about rulings from the court, and you are well aware of them. So to say that the government has some connection to the way the magistrate ruled in the particular case is simply wrong. It's simply wrong. As you may know, the parking meter case, Smart City Solutions Holding Inc. against Guyana, that is currently pending at the International Center for Settlement of Investment Disputes, ICSID, was fixed for hearing from the 1st of September to the 5th of September 2020. These dates were fixed months ago and long before the President's announcement that the 1st of September will be the day that national and regional elections will be held in Guyana. Many witnesses are expected to travel from Guyana to attend these hearings. The Attorney General is expected to be present as well. As a result of 1st of September being the day fixed by His Excellency for national and regional elections, an application was made to the ICSID Tribunal for an adjournment of the hearings, and that application fortunately was granted, and the hearings will now take place from the 29th of September to the 4th of October. So we were successful in getting an adjournment of the hearings from Elections Day to the 29th of September to the 5th of October. I see Mr. Ralph Ramkaran in his Sunday Stabrook News article being very critical of comments I made on this program regarding the case filed by Christopher Ram challenging the electoral system of Guyana as is established by the Constitution and the Representation of the People Act. Mr. Ramkaran's son, Kamal Ramkaran, is appearing for Mr. Christopher Ram in the case. Now, Mr. Ramkaran is a senior counsel and senior to me, and I've never disrespected Mr. Ramkaran, and I will not do so. But I just wanted to say that I understand why Mr. Ramkaran wrote what he wrote. The purpose of the article was not to express Mr. Ramkaran's opinion on the law. That was not the intention of the article. The article was an attempt by Mr. Ramkaran to distance his law firm from a statement that I made. Well, to distance his law firm from a contention that I advanced. And the contention that I advanced was that based upon the information that I have received, information that I have no reason to doubt, the legal proceedings are being financed by a political presidential aspirant. I suspect that Mr. Ramkaran recognizes the implications and the repercussions that may flow from his law firm being connected to that presidential aspirant, and therefore thought it necessary to direct his ire and wrath at me for making a connection between the proceedings and that particular individual. The whole purpose of Mr. Ramkaran's article was to deny and reject a connection between that presidential aspirant and the proceedings, having regard, as I said, to the potential repercussions and implications it may have for him and his law firm. And I suspect in the process he was a little insulting. But that's okay. I guess when you express views publicly, you are open to public criticisms. And I just want to assure Mr. Ramkaran that I have not exposed him or his law firm to the dangers or potential dangers that he's wary of. Somebody within his law firm has done that, not me. So he's directing his wrath and his ire in the wrong direction. It's Kamal Ramkaran who filed the case. And that is where whatever anxieties the case may excite, that is where the anxieties must be addressed. So I thought that I would just put that to rest so that I can assure Mr. Ramkaran that it's not me. He should channel his energies elsewhere. And as I am on that topic, let me speak a little about the proportional representation system, because I like to make this program interactive and informative. So in the English Commonwealth, we have by and large two types of electoral systems: a first past the post system and a proportional representation system. As I said before, we had a first past the post system from 1953 to 1964, and then we changed it to proportional representation. And there is a long ongoing debate regarding which is the better system, which is the more representative system. And academics as well as practitioners have in the main concluded that the proportional representation system is the more democratic and more representative of the two systems. That in a proportional representation system, every single vote counts. But in a first past the post system, the person who gets the highest number of votes for a constituency wins the election. So if you get, for one constituency, you have 100 votes, and one person gets 51, and the other one gets 49, that 49 votes is disregarded completely. And the one who gets 51 gets that seat, because only one person can get the seat. So 49% of the vote go down the drain. In a PR system, that 49% of the vote will still be counted for the allocation of seats. You may lose the government, but you will end up getting seats. And the last elections in Barbados, I think, perhaps more than many, has crystally clear demonstrated the advantage of the PR system over the first past the post system. So at the last election, the Barbados Labour Party got 78,720 votes. 78,720 votes. That is, they got 69% of the votes, and they got 30 seats. So they got 69% of the votes cast, and they got 30 seats. The other two parties, the Democratic Labour Party, got 30,000 votes, 30,273 votes. That is equal to 26.55% of the votes. And the next party, Alliance for Party for Progress, got 3,205 votes. That's 2.8% of the votes. And neither of them got a seat. So between the two parties, they got nearly 30%, one-third of the votes cast in elections without a single seat. Barbados Labour Party won all the seats with only three-quarters of the votes. Less than three-quarters of the votes. Less than three-quarters of the votes. These people had almost one-third of the votes cast, and they got not a single seat. That, I believe, demonstrates very clearly that the PR system is a more representative system. And maybe that's why that system was chosen and remains the electoral system of Guyana with some modifications. But it is not what the lawyers are saying it is. Article 160, in my respectful view, is completely being misinterpreted. But we will know who is right and who is wrong when the judge rules. It's not my intention here to argue the case or to try to persuade anybody. Like Mr. Ramkaran, I have been in the business not as long as him, but for a sufficiently long period of time to know that the court will rule soon, and we will resolve the matter. I'll come back to you and I'll report to you how the court has ruled and who the court said is right and who the court says is wrong. So please remember to share the live. Churanlal Silochan, Shamogir, things seem to have stuck. I'm not seeing the messages scrolling anymore, but please share the program so that all your friends and all your followers can join us in our discussions tonight. I want to spend some time in dealing with some of the new offenses and old offenses, criminal offenses that are in the Representation of the People's Act, or offenses that are created by the Representation of the People's Act. And it's a good thing that I do this to publicly make aware or to bring public awareness to the serious offenses that the laws create in relation to elections. Because as you know, we have a history in Guyana of misbehavior, let me put it that way, at elections time, both by political parties and their supporters, as well as by officials who are manning the electoral machinery. And I thought that it may be a good thing to remind you, the listeners, of some of the offenses. In particular, since I saw a clip, a video clip of Mr. Norton, opposition leader, saying that he will advise his polling agents that if they hear foreign language in the polling station, then they must prevent the voter from casting his ballot. Now that's a highly irresponsible and reckless statement for a political leader to make on the eve of elections, or at any time whatsoever. First of all, there is no electoral system in the world that will bar a qualified elector from exercising his or her franchise on the basis of his language or his lingual inabilities. In other words, no system will bar the exercise of a right to vote because a person cannot speak a language, a particular language. Any country that you go to in the world that is considered democratic has in its laws the facilities to ensure that every registered and qualified elector is allowed to exercise the right to vote. Language, or the lack of a particular knowledge of a language, has never been held to be a disqualification to vote. And we don't have any such disqualification in Guyana. You can take whichever country you wish. If you take the United States of America, no doubt millions of qualified electors vote at US elections who do not speak or may not even understand the English language. Millions go across the border to Canada and it's the same thing. Go to United Kingdom, it's the same thing. Many civilized worlds, many civilized countries, you would have persons who are qualified to speak in a particular language or speak a particular language and not being able to speak the native language of the country, and that will never be a disqualification from exercising one's right to vote. So that's the first thing. Guyana is in that league of nations. Secondly, that would be discrimination which our constitution will not permit. It would be discriminating against a person on the basis of his language, which may be tied to his culture, which may be tied to his religion, all of which are outlawed by our constitution. That is the second point. Thirdly, it would be a manifestation of xenophobia to target people because of their language. It would be an act of xenophobia, which is an international crime, were we to move in that direction. Fourthly, our Representation of the People Act creates a series of offenses for anyone who obstructs or otherwise interferes with a person's right to vote once that person is a registered elector. And 78A of ROPA makes it a criminal offense. Any person who, without due authority, obstructs or otherwise interferes with access to or egress from a polling place. B, the voting at an election by any person registered as an elector. C, the conveyance of documents, supplies, and other materials pertaining to an election, including ballot boxes or ballot papers. D, the counting of votes cast at an election. If you interfere with that. E, an election officer in the exercise of his functions conferred upon him on this act. And to interfere with any polling agent, election agent, assistant counting agent, etc. All election officers, if you interfere with them or you obstruct them in the execution of their task, their legal functions, then such a person shall be liable on a summary conviction to a fine of $5 million, together with imprisonment for a term of 3 years, and shall in addition be incapable during a period of 5 years from the date of conviction, 1, of being registered as an elector, and 2, of being elected as a member of the National Assembly. So not only will you be charged and be subject to a fine of $5 million, together with, not or and, together with, meaning you're going to pay the fine and serve a term of imprisonment for 3 years. And then in addition to that, you are going to be disqualified from voting, and then you are going to be disqualified from being elected as a member of the National Assembly for 5 years from the date of your conviction. So those who are being encouraged to create these kinds of obstructions and interference, this is what the law lays out very clearly. And this will be the consequence that will flow from your action. Also, there's another offense. Any person who, with the intention of misleading an elector on the day of poll, A, deliberately providing misleading information to the elector, or B, deliberately making a misleading statement of a material nature to the elector, commits an offense and is liable on a summary conviction to a fine of $5 million and imprisonment for 3 years. So if you try to mislead an elector, this is an offense that you can be charged with. And that's in section 78B of the ROPA. There are a whole series of these offenses. I'm just reading them, choosing a few to highlight. And then our law also takes into account and provides for persons who cannot speak the English language and who may wish to vote once they are registered, of course. And it says, section 72, a very long section, and subsection 10 speaks to where a person who doesn't understand the language spoken to him, he can appoint an interpreter with the concurrence of the presiding officer. So if there is someone who comes into the polling station and who can't speak, whenever in the opinion of the presiding officer, the elector does not understand the language spoken to him, so if he does not understand the language spoken to him, he may appoint and swear an interpreter in a form that is there. And the interpreter so sworn shall be the means of communication between the presiding officer and the elector in regard to all matters required to enable the elector to vote. So, and this was in the law since 1997. This is not a new amendment that we put in. This was always there since 1997. So our law, 30 or more years ago, contemplate a person speaking a foreign language voting in Guyana. And we have always had Commonwealth citizens being able to vote in Guyana once they are residing here for 1 year and more. And that has been with us in our Constitution since independence. That's nothing new. Since 1966, every Commonwealth country, 55 of them or more, I think it's 55 of them, has that provision. It's a reciprocal provision that is in all Commonwealth constitutions that allow Commonwealth citizens to vote in the country in which they are residing once they establish that they have been residing in that country for 1 year and more. You would recall there was a case where a professor from Dominica who was living in Barbados was prevented from being registered in Barbados as an elector in the 2020 Barbadian elections. And he filed proceedings a few days before the elections. And the case went all the way to the Caribbean Court of Justice. And the Caribbean Court of Justice ruled the Sunday before the elections. The elections was fixed for a Monday morning. On the Sunday before, the Caribbean Court of Justice ruled that the professor, being a Commonwealth citizen, living in Barbados for over a year, was entitled to vote at the Barbadian elections. So these matters are part and parcel of our laws and part and parcel of Commonwealth legal systems. They're very similar. So we don't have to invent the wheel here. There are precedents that are set across the Commonwealth that we can turn to for guidance. And our own legal framework contemplates and provides for many, many of these scenarios. So anyone who thinks that they can get persons to obstruct and interfere with electors who are registered and who are qualified to vote from exercising their right to vote, well, they have legal consequences of a highly punitive nature that will come their way. I thought that I would just raise that because I saw that circulating somewhere. Somebody drew to my attention statements made by Ganesh Mahipal rehashing the whole AG being advised by GCOM issue. I don't have the time nor the energy to repeat what I said on this matter. I think that I was reasonably clear, and I think that I have put the matter to rest. I am not the legal advisor of GCOM, but many state agencies that are constitutional bodies of an independent and autonomous nature seek time and again the legal guidance of the Attorney General's office. And historically and conventionally, the Attorney General would oblige. More particularly, the guidance relate more often than not to legislation and the interpretation of those legislation, because the Attorney General Chambers is responsible for drafting the legislation. And when you are interpreting legislation, the intent is to find out what the drafters mean when they write what they write in those laws. What is the intent of the draftsman? That is how you interpret. And if you have access to the draftsman, why not seek his guidance? And that is how that relationship has developed and has evolved. As I said, when the APNU AFC was in government, the GCOM did the same thing. In fact, their commissioners, Alexander, Corbin, and Trotman, sought the advice of the Attorney General Chambers. Mahipal doesn't know that. Or if he knows, he's lying and he's not being truthful. Let him ask, and that's why I challenged those three gentlemen. And those men wouldn't stay idly by if I challenged them. Trust me. Every time they want an opportunity to get into the press. And if I am wrong, they would have come out and said so. They know. Because as I said, I saw them going in and out of the Attorney General office during that 5 months period post March 2nd elections. So they can't tell me that they never go there for legal advice. And the staff is there anyhow. I'm not trying to throw the staff under the bus. I'm speaking the truth. The staff doesn't have anything to hide. They're not politicians. If their assistance is needed, they offer it. GRA is an independent body. They come, they get legal advice on a regular basis. Many, many state agencies. That doesn't mean that they are under the control or authority or influence of the Attorney General Chambers. And as I said, the advice from the AG office is not binding. They don't have to accept it. They don't have to accept it. It is simply to assist. offer assistance that is being sought. And then the last issue that I want to deal with is the issue of prisoners voting. Now, and this is how you know that the PNC and their representatives at the GCOM are engaged in frustrating and obstructionists' strategies. Because the PNC is not a stranger to electoral politics in this country. They have been engaged in electoral politics in Guyana since 1957. Over 7 decades ago, they have been engaged in electoral politics. They governed the country for 28 years. And then another 5 between 2015 to 2020. They never championed the cause of prisoners voting during all those years. There has not been any change in the law since. How all of a sudden, 3 months before elections, this is an issue of some contention. Never before. They didn't know that they wanted prisoners to vote when they were in government. From 1964 to 1992, they didn't know that prisoners were not voting then. And even before that, in 1957, they didn't know that prisoners were not voting in Guyana. Since elections started in Guyana in 1953, Borden was around all those years. Vincent Alexander has been in politics before I was born. Trotman may be the same. Corbyn, these are gentlemen who are in their 70s. They're not spring chicken. They don't know that prisoners ever voted before. And suddenly, prisoners have a right to vote. The position is that historically, in the Commonwealth, and that's the system that we inherit, the Commonwealth legal system, inherited from England, the English legal system that was passed down to Her Majesty's Commonwealth. Prisoners generally did not vote in England for hundreds of years. And that system was passed down, that tradition and that convention was passed down. Prisoners, when they are in prison, they lose their freedoms. I suspect that philosophically it may have been felt that that part of their freedom, the right to vote, I am surmising, I don't know the reason why, it may have evolved that way, that part of your freedom would have been curtailed by your imprisonment. Because you are imprisoned, you have lost many, many other freedoms and rights that you have. And I suspect that loss of freedom, which your confinement to custodial custody, your confinement to custody, your freedom to vote would have been lost in that process. You have to now have specific legislation to enable that right. First of all, you have to have a policy position whether you want to whether that right should be conferred. Because if you look at the Constitution, once you are sentenced, then many of your rights go. Once you are sentenced by a court of competent jurisdiction. That's what imprisonment is about. The very Constitution that gives you these fundamental rights and freedoms, they take it away by subparagraphs. And one of the subparagraphs, or one of the basis upon which you lose these freedoms, is that if you are serving a sentence by a court of competent jurisdiction. Now, if you want to eke out of that the right to vote, well, then a policy decision has to be made, and then the law has to be adjusted. But you can't spring that on a population and spring that on an election commission 3 months before elections. You clearly want to frustrate the holding of the elections. You want to obstruct elections from taking place. And that will not happen. Because it's a whole administrative arrangement. First of all, you have to have the legislative framework that will be able to enable that right to be enjoyed and exercised. And then you have to have the administrative arrangements, and then you will have to have the logistics, and many, many logistics, to think. And Alexander, Corbyn, and Trotman must know that none of these things can happen in 3 months. But they were still arguing it before the commission. And that is how you know that these guys can't be genuine. They cannot be genuine. They are not genuine. They cannot. And that's why when they purport to speak as though they are Democrats and they advocate these causes for freedoms and liberties, you know that it is hollow. You know that it is hypocritical. You know that it is duplicitous. It is to achieve an ulterior motive. And in this case, the only ulterior motive would have been to frustrate and delay the elections. And they have lost abysmally. They have lost abysmally. Because there are hundreds of countries in the world that do not permit prisoners to vote. So I thought that I would express some views on that issue, as that have been a burning issue in the public domain. And I didn't want to preempt a discussion, or rather, I didn't want to preempt GCOM concluding its deliberations on the matter before I speak, lest again I be accused of trying to influence the decision-making process at GCOM, or worse yet, interfere with the decision-making process at GCOM. So I held my peace until I think they had the matter resolved and conclusively dealt with at GCOM. And then I decided to speak. So my operator is signaling to me that we have come to program time. I want to thank you very much for being with me over the past week or so, for being with me for the past hour. I'm distracted a little tonight. And I want to thank you very much, and I'll see you next week as we continue our discourse. There's going to be some point in time where I will have to I will have to adjourn a few of these programs because the election campaign will begin and then will intensify. And obviously, I will be on the hustings every night across the country. And that will keep me away from the program, but I'll continue to be with the program as long as I possibly can. Once again, I close by encouraging all of you who, for whatever reason, is not yet or are not yet registered. Tomorrow is the final day. The registration centers close at 8 p.m. So you have the entire day till 8 p.m. in the evening to go. Once you're qualified and your name is not on the list, go and have your name on the list. And significantly, if you need transfers to be done, if you are living in one region or you're living at a place and you are registered at a different place, you need transfers to be done. Tomorrow is the last day for that to be done. You need your transfers to be done if you're living in one region and you get a house lot in another region and you and your family move to that new region, but you're registered still in the old region, you will not be able to vote on election day at your new home or in your new neighborhood unless you effect a transfer. And tomorrow is the last day to do that. So please take advantage of this last opportunity. Thank you very much, and I'll see you next week. May God bless you.